May it please your lordships, I am Sham Gadiat, Junior Counsel for the appellant Mr. Jeffreys, who is head teacher at Bexborough College. My learned friend Omar Tara Aleiko has already addressed your lordship on the first ground of appeal. I will now put forward submissions for the second ground of appeal, which is as follows. We submit that based on the weak assumption that Miss Martin enjoyed a substantive legitimate expectation, our client, Mr. Jeffreys, departed from that expectation based on a proportionate measure in the circumstances. In support of this appeal, I have three submissions. Turning to my first submission, I would like to make reference to Nadaraja against Secretary of State for the Home Department 2005, which can be found at 1363 of the Court of Appeal for England and Wales Civil Division. Would my lords like to be reminded of the facts of the case?
Where is that in the bundle?
It is on page 8 of the bundle.
Thank you.
Would my lords like to be reminded of the facts of the
Yes,
case? The case involved two appeals which raised issues regarding a Secretary of State policy which was revised during the application process. In the first appeal, it was held that there was no legitimate expectation. However, in the second appeal, it was held that there was a legitimate expectation, but due to the claimant's error, the Secretary of State misinterpreted the facts and was able to depart from their expectation without being disproportionate or unfair. Within this case, Lord Justice Laws makes reference to the case of Coughlin, which has already been introduced to your lordships by my learned friend. My lords, if I could ask you to refer to page 8 of the bundle at the highlighted area within point 51. In this reference, Master of the Rolls, Lord Wolf, as he was then, put forward that where the court considers that a lawful promise or practice has induced a legitimate expectation of a benefit which is substantive, not simply procedural, authority now establishes that hereto the court will in a proper case decide whether to frustrate the expectation is so unfair that to take a new and different course will amount to an abuse of power. Here, once the legitimacy of the expectation is established, the court will have the task of weighing the requirements of fairness against any overriding policy which was relied upon for the change in policy. So what can we infer from this? To put it simply, we must establish whether or not the decision to depart from a legitimate expectation is unfair on the individual in question, and as a result, would the public authority have abused its power? In order to do so, the courts must balance the interests and objectives of all parties, including an overall view of the public interest, which is the most significant factor. I shall come back to this legal principle in my second submission. My lords, turning to my second submission, I would again like to make reference to Lord Justice Laws in the case of Nadaraja, who put forward that a public body's promise or practice as to future conduct may only be denied, and thus the standard I have expressed may only be departed from, in circumstances where to do so is the public body's legal duty, or is otherwise, to now use a more familiar vocabulary, a proportionate response, having regard to a legitimate aim pursued by the public body in the public interest. My lords, you may find this highlighted within point 68 on page 9 of the bundle. The Honourable Judge suggests that a proportionate response is, in other words, a legal duty imposed on the public authority. We submit that the legitimate aim of Mr. Jeffreys was to prevent disciplinary issues. One must look at the bigger picture in terms of what did Mr. Jeffreys actually foresee when deciding that there would be disciplinary issues. Had he not departed from his promise made to Miss Martin, Mr. Jeffreys would have been in breach of Section 51, subsection 1 of the Equality Act 2006. It states, "It is unlawful for a local education authority in England and Wales, in the exercise of their functions, to discriminate against a person." Mr. Jeffreys was under a legal duty to not breach this response, or to put it differently, my client took a proportionate response in the public interest to avoid breaching the Equality Act, which subsequently would have led to disciplinary issues.
How are you saying who's discriminating? So unclear. How is this headmaster discriminating? Martin.
Discrimination in the fact that the 17 students would be wearing black and grey trousers, whereas everyone else would be wearing pink skirts.
And it wasn't for religious reasons, and it wasn't. It was just as a question of, as a matter of choice, and I understand because they thought they'd be ridiculed on the way to and from school. And do you know if there was a consultation with the students before the school uniform was changed?
It was only changed for the 17 students. There wasn't a consultation with the existing students, no. So they weren't told anything. They were basically being discriminated
It says in 2005 the college instituted a new uniform policy.
He means the initial uniform policy, when that was changed, when girls were asked to wear out and skirt. Was there a consultation with the students?
No, there was not.
You know that for certain?
We don't have enough information based on the facts that we've been given.
You don't know?
No, so it's an assumption that's made.
You can't say you don't know. You can't say no if you don't know. Please carry on.
Thank you. To put it differently, my client took a proportionate response in the public interest to avoid breaching the Equality Act. His legitimate aim was to avoid this under all circumstances. Applying the legal principle found in my first submission, it would be unjust to suggest that Mr. Jeffries abused his power and was unfair to Miss Martin simply for the reason that he intended to abide by his legal duty by preventing a breach in the law. Even so, it may be argued that Miss Martin enjoyed a detrimental reliance upon my client's promise of allowing her to be exempt from the normal uniform policy. My Lords, this brings me to my third and final submission. Detrimental reliance is a similar concept to one found within contract law known as estoppel. In this case, my learned friends opposite may argue that Miss Martin enjoyed a detrimental reliance upon the promise made by my client. I would like to bring to the attention of your Lordships my client's motive. Upon making his promise, Mr. Jeffries more than likely intended to allow these students access to education as per section 1.23 of the school.
I'm going to stop you on that point, because you're preempting a point that they haven't necessarily made. I would give you an opportunity to reply in that way if they make that point. I don't think it's fair to hear the point jumping the gun, so to speak.
With all due respect, my Lord, I preempted the point before we received the opponent's skeleton argument.
But they haven't made the point. I'm telling you that I want to hear it in response. I don't want to hear it as a preempter.
My Lord, would it...
Move on to your next point.
Those are my submissions, and my Lords, if I could jump to my conclusion. My Lords, I shall now turn to my conclusion. Within my submissions, I have defined the law and applied the law. The public authority must have an overreaching legitimate aim in the public's interest in order to depart from its promise, irrespective of any detrimental reliance. My client's overreaching legitimate aim in the public's interest was to avoid disciplinary issues deriving from discrimination. With all due respect, it would be absurd to hold that in preventing a breach of law, my client has acted unfairly to Miss Martin. For these reasons, the remedy we seek here today is for your Lordships to overturn the rulings of the lower court and the appeal be brought in favour of the appellant. Unless I can be of any further assistance, those are my submissions, my Lord.
Clearly, in accepting the offer from Begsborough College, Ms. Martin rejected offers from other colleges. So she clearly has suffered as a result of the U-turn on policy that the principal of the college made. Surely we ought therefore to look at this case a little bit differently.
If I could refer back to my third submission, where I was discussing detrimental reliance, a point I would like to make would be that... Sorry, could you just go on? In the case of Nadaraja, at page 10, at point 69 on your bundle, the Honourable Judge suggests that where the representation relied on amounts to an ambiguous promise, where there is detrimental reliance, where the promise is made to an individual or specific group, these are instances where the denial of the expectation is likely to be harder to justify as a proportionate measure. Note the key word, harder, which implies that it is not impossible to depart from a promise which has resulted in a detrimental reliance. If you look at the case of Coughlin, the health authority had failed to establish that there was an overreaching public interest which entitled it to break its promise. However, in this case, we do have an overreaching public interest that of preventing a breach in the law, the Equality Act 2006.
Thank you.
Those are my submissions, my lord. Do you have any further assistance?